Okay, everyone, we're at the hour. So welcome to this session on open law, how open source technology, neutral citations, and PACER reform can transform access to justice. I'm Jessica Frank. I'm a project manager at Free Law Project, and I work at the intersection of law, technology, and access to justice. So our legal system is built on precedents, right? So legal decisions shape lives, they determine future outcomes. Therefore, accessing the law should be a right, not a privilege. And justice shouldn't depend on your access to a paywalled system. A lack of access limits participation. It's particularly harmful to low-income or self-represented litigants who don't have large legal research budgets, but are still held to the same procedural and legal requirements as lawyers. It's also problematic for researchers and journalists who are trying to look at large-scale trends in our justice system or to be watchdogs on the third branch of government. These people need access to legal data en masse, and the current paywall system makes that difficult and very expensive. Our justice system needs to be transparent. Transparency builds trust and accountability in our system. We are at a pivotal point in our democracy here where public confidence in government is at an all-time low. So anything we can do to increase transparency and accountability is good for the country. So what's blocking access? We're facing three big barriers: proprietary citations, PACER fees, and lockdown legal research tools. So each of these keeps legal information out of the reach of people who need it the most. So let's dive into each one of them and look at how each of these systems plays out in our, each of these problems plays out in our justice system today. The first issue is proprietary citations. These are legal citation formats that are owned oftentimes by commercial publishers. So a court hands down in a written opinion in a case. The case is then set to be published because it has precedential value. It's edited and published in a legal reporter. Courts, libraries, and lawyers spend millions of dollars to access and then comply with these proprietary systems. This limits innovation and makes open access harder to achieve. It's simple and it's small, but these issues about the citation can be a barrier to access. So what can we do about it? As an alternative, as a public path forward, we have something called neutral citations. Most of you might be familiar with it, but neutral citations are court-assigned, vendor-neutral references to a case. They're very easy for a court to implement. Here is a before example. In this particular case, it's Washington 2nd, refers to the Washington Reporter, 2nd series. And then there's also P 3rd, which is West Pacific Reporter, 3rd series, pagination. And then there's often copyright claims related to that pagination. In the alternative, this is the same case. If it was published under the neutral citations, the parties, the year, the court that is publishing it, and the order of how that opinion was handed down over the year. So in 2011, the Washington Supreme Court, this was the second opinion handed down, and the court added pin sites so that they can actually be properly cited. Effectively decoupling a judicial opinion from its appearance in a particular publication, print or electronic. It makes it neutral citations. So neutral citations are efficient and effective because they increase transparency, access, and tech innovation. They are court assigned, and so this content comes from the court. Therefore, the citations should as well. So 5 benefits to neutral citations. Standardization. So it is whatever the reporter, wherever it is appearing in print, in digital format, all of them have a consistent way of referencing cases across jurisdictions. It's accessible, so legal information can be freely accessed through these. You're not waiting around for a publisher to get through their publication cycle or to put the content out. The opinion is available immediately as soon as the court issues it. It's also stable, and so you don't have to worry about citations changing over time. It's a permanent identifier because it is coming from the body that released the case. And it's compatible, so you don't have to worry about different systems, having to do conversions and that kind of stuff. It's easy to integrate, and that promotes technology and supports research, other judicial decisions, and legal writing just is made easier when the citations are in a standardized format. Neutral citations aren't just a thought exercise. This is something that exists in the wild. These are just some samplings of it. Many states in the US and Canada, in the UK and New Zealand all have neutral citations and have had them for years, but the impact has been huge. Neutral citations reinforce the idea that the government produced this work, so the public owns the final product. It makes case law vendor neutral, technology neutral, medium neutral. It doesn't matter the format in which it is displayed to the user. And so it lowers costs, eases access, and creates a public-friendly citation system. Basically, it's very easy for courts to do this. All they have to do is publish the citation. And so there's a lot of concern in the courts, or, you know, the legal system is based on how we did it when Thomas Jefferson was around. And so arguments are like, well, we've never done this before. How can we do it? And you're like, just do it. You're the court, you're the entity, do it. And so a lot of that is in advocacy, and that's where people in this room can come forward and say, you can promote the different ways in which you can push this. We have a page on free.law/advocacy/neutral citations that you can see different roles, whatever role you're in, suggestions on how you can push this advocacy forward. But mostly the counter is just go do it and add paragraph numbers and you guys are okay. And courts have done it. So that's also a big selling point. You're not the first one to do this. And it's happened over time. So the world didn't blow up when New Zealand started using neutral citations, or the state of Illinois. The second blocker is PACER. So in case you're not familiar, PACER is public access to court electronic records. It's the main access point for federal court dockets. It's telling us what's happening in our federal court system. It is basically also emblematic of outdated government technology and infrastructure. PACER charges 10 cents per page. The 10 cents is a historic artifact for when the system was a dial-up 30 plus years ago. A lot of courts have, like, if you had to actually print something or make copies, it cost 10 cents. That's just a silly artifact that we're still relying on that. It doesn't reflect anything in terms of what the cost for giving that content to the public is. You can't hyperlink to cases in PACER. You can't search across courts. The interface is 30 years old and it looks like it. We're circling back to the 90s, so maybe it's vintage at this point, but it's not great. And worst of all, it's expensive, right? So many lawyers, especially those in small firms or in legal aid, can't afford to search freely. There's both the financial burden and the antiquated technology that burdens users who just want to access public legal data. It limits journalistic investigation and civic oversight into our federal court system. It's also problematic in terms of the revenue generating that it creates for our federal court system. PACER generates $140 million in revenue each year. That is unclear how that is being spent in terms of it's a slush fund for the judiciary without the congressional oversight that is supposed to be related to it, and justifications for the need to charge for this access to this content and maintain the technology, that the whole point is that we have to charge for because this is what the system costs, and that, you know, we're breaking even. That's not holding water in real life. So they have this $140 million, and the system clearly isn't costing $140 million to run year on end. We see this a lot in court technology. Just as a side, there's a lot of justification for courts don't have money to modernize or to go to e-filing systems for self-represented litigants or automate documents, but they have the ability to spend $1 million a month on proprietary software. And so as Sam was saying, like, the outcomes, it shows what it is. They do have the money. It's just where they want to spend that money that matters. And so this is an area where they're not spending government money efficiently. And it's time for modernization. So what can we do about it? The federal judiciary has shown an unwillingness to modernize. They push back on lots of different ways in which people are trying to move that PACER system into the 21st century, 25 years into it. And they don't listen to user demands. And they don't even care if the tech's not really secure. And if you think about this is the corpus of our third branch of government, and they have shown repeatedly that it is insecure. And there are actors, foreign actors, that have accessed the PACER system without any sort of real fix in place on that technology. So there can potentially be national security concerns. So Congress has stepped in. This is an example of a legislative fix potentially called the Open Courts Act. It's currently in the 2025 version. There was a 2023 version that didn't make it all the way through the congressional process. Every time I talk about it, I think about that song, like, I'm just a bill on Capitol Hill. It didn't make it. The bill was sad and crying. It didn't make it all the way through the process, the little guys. But the Open Courts Act, the 2025 version that we've been working on, is bipartisan. Senator Kennedy is a Republican out of Louisiana, and Senator Wyden is a Democrat out of Oregon. Both of their offices are working on that with Free Law Project and with Fix the Courts to eliminate PACER fees, to create a modern system that has standards, that it has advisory groups and user testing, and is created in an agile format. And there's just a lot of, this isn't 1998 anymore. Let's actually do this the right way, and eliminating fees for access to PACER. But it needs help. So like any legislation, Congress moves forward on what hopefully people are telling them needs to happen. So this is another area of advocacy that you all in this room can do direct advocacy by calling your representatives. Or you can follow along in the process and support it and talk about it and how this is an efficient and effective way to solve a big problem in our federal judiciary. So it is fixable with the right pressure. The third blocker on my slide deck was closed legal tech ecosystems. So the high costs limit who can participate. So proprietary platforms charge steep licensing fees for access to tools and data. Courts and law schools and libraries and the public can't afford to participate in equal footing. In the session that was in this room before lunch, they were talking about, well, we can't have full access to X tool because we're at a law school library and we don't have the money for that kind of budget. That's the whole point. It is reinforcing the disparities between well-funded institutions and under-resourced users. Vendor lock-in prevents innovation. So courts and firms become dependent on a specific vendor, making it hard for anyone to adapt or create new and more equitable tools, or to build technology for those who maybe can't afford it, like self-represented litigants, on top of closed proprietary systems. The opaque systems undermine trust in the system. If you can't see the code and the data underneath, or the algorithm, how can you trust that decisions are being made and that they're being made fairly? And the secrecy is eroding the trust in the legal outcome, especially with any introduction of AI-related or AI-driven processes. Data silos inhibit research and oversight. So researchers, journalists, public interest groups can't analyze, they can't audit the system, and because they can't access the underlying data. And then it also excludes community-driven solutions. So tools for innovation that comes from the legal aid community, or that is for pro se litigants or non-English speakers, or something that is out of the norm where money and capitalism, generally revenue is going, is stifled because the developers don't have access to the closed platform. So an open source and open ecosystem encourages adaptation, while closed systems don't. Closed systems lock out everyone who can't pay or who can't conform. And so our work at Free Law Project is the opposite of that. We build public goods that are free to use and to adapt. We believe that access to the law shouldn't depend on who your employer is or whether you can afford a subscription. So that's why our tools are open source and our data is open and available, because we see this as a form of public infrastructure, not just software. And so that's building the infrastructure of access. Tools like Recap and Court Listener make court data accessible at scale. Recap helps the public to collect and share federal court records that are otherwise locked behind that paywall. We have something like 500 million docket entries from the PACER system that are contributed through roughly 30,000 people have a browser plugin in which they are sharing PACER data back with us, plus scraping tools, building out that corpus of public data. And we also have a system called Pray and Pay. And so if there is a document in PACER that you want that isn't in our system, you can request it and hope that generous benefactors in this open source community can get that form for you or that document for you. We support a lot of journalists that are tracking court activity. We support pro se litigants preparing cases, researchers analyzing legal trends. For example, journalists have used Court Listener to break litigation, to follow breaking litigation across the country. We have bots on Blue Sky that follow big cases, smaller cases, specialized around a specific area of the law, or in general, just the big news. There's a whole bot around Trump litigation. There's a whole bot around LGBTQ issues. And so you can tailor your experience and see what is going on in the legal system around your interests with the bots. Because they are open source, anyone can inspect and build on top of the tools. And so all of our content is available either through the APIs if you want to access the databases, or through GitHub if you want to use the underlying technology as well. And it's not just tech. This is a civic resource that is being built by a community of people who are contributing. And when we talk about access to justice, we're not just talking about the lawyers or the law firms or the judges. We're talking about the ability for everyone to understand, participate, and trust the legal system, and open tools make that possible. One of the open tools that I've been working on is the self-represented litigant portal that we're building. So we've talked a lot about infrastructure, about open source tools, about public data, about building systems that support access to justice. And this is one of the ways that we are putting this into action. So we are piloting a litigant portal that is a new tool that is specifically for people who are representing themselves in court. It's like a case dashboard. If you've ever visited a doctor and they ask you to sign up for their portal, sign up for the medical blah, 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 My Doctor app. It's a similar experience that doesn't exist in the law, but the idea that you can interact with a system outside of normal business hours, that you can get information about your specific case, tailored to the jurisdiction you're in, that you can get self-help materials. There have been 30 years of automated forms and self-help materials created by courts and legal aid organizations that can be pulled in to help people in the moment in which they are their own lawyer. I was recently in Virginia observing a pro se day, and people didn't know where to stand. They walked into the court and they didn't know who the parties are to talk to, and it's very intimidating. And it's, even you stand at this table, and if you're this person in the party, you stand at this table, and here's the clerk, and you have to check in. All of that content is knowable and can be provided to people before they show up at court and are confused and overwhelmed. So it's more than just form filling, it's the entire experience. Our portal will also likely be integrated with e-filing in the pilot that we're working on, so that they can take their automated form, learn about their problem, fill out the forms, and then submit them to the court. With integration into the court's case management system, they can get reminders like, hey, a text message reminder, you have court coming up in 3 days. Make sure you show up. Here are the 5 things you should bring. And then, this is due in 3 or 4 days. Whatever it is, you could help give people assistance through low levels of technology. We are in the early collaboration phases, so we're in the wireframing. This is a screenshot from some of the wireframes that I was sharing with our partners. It is a platform that would allow the jurisdictions to fill in the content that they had. And so it's agnostic to the document assembly tool that they may have in place, or the legal self-help materials that are already created that can be pulled into the system and displayed to the end user. And it can be as robust as this is the 5 areas that this court wants to focus on, but it could be scoped to be larger or smaller, depending on the issue. But the litigant portal is going to provide information. It's going to help people fill out and then e-file their forms. They'll get notifications. They will have a way to securely store their case documents. So if they need to show daycare, the court order that says dad can't pick up the kids on Thursdays anymore. They'll have an access to that on their phone or through digital website, through the website. If they need to have copies because God forbid they had to leave their house and they can't take their court file with them, there's a way for them to store their data securely as well inside of the portal, all depending on our pilots that we're going through. All right, so we've talked about the systems, the PACER, the proprietary citations, the open source tools that can help shift the landscape. But let's talk about you all for a moment. Change in this space doesn't come just, it's not going to come from Congress only or from the courts. It can come from other institutions that are fundamental to our democracy. So people in academia, in tech, in libraries, who are deciding to do things a little bit differently. So law schools, you are uniquely positioned to drive cultural and practical shifts. You are the ones who are teaching the lawyers of the future. And so you are helping to shape their perceptions about what is and what should be in the future. You can train them on open tools. So show them, just like you're teaching them how to use Westlaw and Lexis, and they have those integrated into their legal research courses. Teach them about Court Listener and about Recap or about other free access tools, that it doesn't have to require a subscription to learn about the law and to build technology on top of it. Teach them about neutral citations. So yes, you have to learn the proper way to cite, but if a neutral citation is available, teach that as a citation format in legal writing as well. Developers and technologists, whether inside or outside of the legal space, can play a huge role here too. So contribute to open source, build new features, help deploy tools in ways that scale. You don't need to be a lawyer to solve legal problems. As we heard in the keynote, there can be different levels of interaction in the legal system. Not everyone has to be the surgeon, but you still can provide fundamental care that people need. And then librarians and IT staff. So you are often the quiet engines of innovation. You're the ones who are going to decide what's on the shelf. So what's on the internet, what students and faculty use every day. So promote open source tools, ask for open APIs. So in the session earlier before lunch, there was a question about like, how do we change this or how can we negotiate? You are the purchasers. Negotiate the contracts. Don't let the vendors just set the standards. At least start asking for APIs and open APIs. That's what we've been pushing with courts as well. The courts are like, well, this is how it comes. Like, no, you're purchasing $100 million product. You have a little bit of say in whether or not it can be open or that the tool provides APIs so that people can build cool tech on top of it. And again, to harken back to the cholera example this morning in the keynote. So what is your lever? Where can you push just a little to make something more open, more useful, and more fair? Where can you turn the knob to figure out to move this idea of open access, promoting access to justice forward? All right, so let's end here, sort of in the open discussion, or in my presentation portion on about how to put it in action. So the little baby roadmap on here. Use and teach open source tools, whether you're in a classroom, in a newsroom, or research lab. You can start using open platforms like Recap and Court Listener and others right away. So they're free, they're open, and they're built for this very purpose. Try it out. Same way that we're teaching about AI and how to use it, try it out. Figure out how you like it. Figure out how it works in your workflow. Start implementing open tools in your workflow and see how they work for you. That helps to normalize open legal infrastructure. If you keep using it, keep putting it in front of people, keep talking about it. The second way is to push for those court-issued neutral citations. So it doesn't have to be statewide. It could be as simple as a letter to your local court administrator or a conversation you have at a bar meeting with a judge who gets really gung-ho about it. From our work with the litigant portal, it's come from one judge who is super gung-ho, and that moves the ball forward. And I've heard that in a lot of places. It's just one person that you light the fire under, and all of a sudden you have a huge advocate who is tied into the legislature, who can get money for it, who can get a pilot project through. You just have to light the fire. And so just talk about it. That's another option. Support PACER reform. So the Open Courts Act is long and it's painful and it's in open comments right now with the judiciary. and their AO, but start pushing for change like that and push for transparency in government. It is government funded, and your money is paying for it. And so you should care, and your voice matters in that fight. These aren't distant policy goals. They're practical, doable little steps that you can take to help support open law. So just take the step. So I've talked for 20-ish minutes now. Let's hear from you guys. What's happening in your organizations? What's going on in your region? Is there progress towards open citations or more accessible court data? Do you have questions? Are people using open source tools? Are there roadblocks that you're seeing? Yeah.
One roadblock I suggest, at least with neutral citation, well, two really. One is it's like state courts that have adopted public domain citations. They have adopted different ways of doing it, which that doesn't help anyone.
Yeah.
And I don't know if they can, I mean, we could kind of lobby them. My state isn't one that has done it, so I don't know.
Yeah.
The other thing is the editors of Blue Book need to get rid of the rule that says if there's public domain citation, you still have to provide the regional reporter, because that's just reinforcing West's dominance, if not, at least oligopoly.
Yeah.
In the space. There's no need for that. I mean, West can cross-reference to the public domain citation. If you have that, you don't need West.
Yeah, there's I think it was in the UK that it was a preference for the public domain one, so that it like the court itself said that's great, that's your citation, but we're the court, and if you are citing to us, you use the public domain, the neutral one. And so the court, this is about at least what I've seen is court empowerment. They don't just have to accept it because that's how Blue Book says it is. No, the court is the official arbiter of how content comes into them. And so the court needs to take the stand and say, this is our citation. And if you are referencing our cases, this is how you reference them back to us. So, yeah.
So just out of curiosity, how did the UK, New Zealand, all that, how did they get their courts to just decide that? Because honestly, throw out the Blue Book, let's have neutral citation. I mean, I think we can all hold hands or sanitize hands and agree, but that's something that we want. It's for the greater good.
Yeah.
But who was the first domino to tip?
Oh man, I don't know the historical background on that one, so sorry. It was at a level of high, right? The AO, the equivalent of their Supreme Court came down and said it, and that's in the states that have implemented. It's generally the states that have a powerful administrative office or a Supreme Court that can set those rules. So it does depend jurisdiction to jurisdiction. And our federalized system is slightly problematic in terms of some judges are elected and some are appointed, and the administrative office has different levels of authority. So I think it a little bit depends on each jurisdiction and tweaking it a little bit. But sorry, I don't have the historical knowledge on it.
Awesome. I'm gonna look into it.
Yeah. You're gonna research. No, this group.
Yeah.
Yeah. Yeah.
Do we know if there are any other states that are on the tipping point that might soon have it, or might these are the best things to concentrate on right now because something's actually going on?
Oh, like a hot one? No, I don't know the hot button issues. On our Free Law website, we have a list of the states that currently do it. I think New Hampshire was the last big one that sort of turned it on, but I don't know if there's a tipping point of here's where to push that button part.
It's is Massachusetts considering it? It's, Alaska about to pass something.
Yeah. Maybe Rebecca knows.
No, I wish. Who's the constituency for this kind of change, the law librarians and legal aid? Who are the people who are arguing for it?
So arguing for it or needing it, I feel are different power sources.
Arguing is what I'm wondering, because I'm wondering who to go to help with that.
Yeah, so I think there is power by lighting a fire or tying it to some other real need. So this is a ephemeral idea about neutral citations or open source. Yeah, that'd be really cool, but how is this going to play out in the real world? And from what I've seen in talking to courts, the push is if you tie it to access to justice. There are 92% of people who are coming in front of them who can't figure out how to fill out forms. And there are millions of people who are facing this huge crisis. here's one way in which you could make it easier courts and an easy win, so that you can start checking off those wins. So I don't know who would be the target or the advocate to tag on with, but if you could tag it onto an idea that is sexy or innovating in the space, I think that's where the real grab is. So fundamentals of our democracy. If the legislatures have fallen, if the executive branch is questionable, the courts are all that's left, right? Like we have to save America by saving the court system. That might sell you in some spaces. If there are millions of people who are facing life-threatening issues, like they're gonna lose their kids, they're gonna lose their house, they're gonna, you know, whatever, their jobs are at risk. That's motivating and starting that fire to get in front of people who can actually make the changes, like the judge in Virginia.
I was gonna say, so this kind of ties in with something that our Chief Justice or former Chief Justice here in Georgia, said, the outgoing Chief Justice, Michael Boggs. He, in his like State of the Judiciary speech this last year, he was talking about like the rural justice crisis.
Yeah.
And on how, like, you know, South Georgia, there are like 159 counties in Georgia, yay. And there are counties that have like 1, 2, like no like lawyers and all, and so like, you know, getting it before like somebody like that who's expressed an interest is like the Chief Justice of the Supreme Court of the state.
Yeah.
Like that's potentially an avenue.
Yeah. It's the lighting the fire under someone who can actually move and figuring out and just having conversation. Connecting to people like at bar associations or at cocktail parties, and you talk about what you do, and then all of a sudden this is a really cool idea. There is money in this, and there's a lot of interest in self-represented litigants and in helping people out, and because we're seeing with the economic sort of not depression, whatever, like this the times we are living in, it is hard for people. And so there is money potentially out there that can also be a motivator, if you can get projects going, or if the court can see that there is money involved to help them with their budgets, that's also a motivator. Yeah.
2 things. Number one, somebody was talking about who's interested. AALL used to be incredibly given. And in fact, there are 2 editions. It is by Manning Jorgensen, the Universal Citation Guide. So it's a natural constituency too. Anybody who wants to publish free law, or even not free law that doesn't happen to be about publishing, is interested in this. Other thing, why not the marketplace approach?
Like,
Why do we have West Side? First place, it's because Mr. West actually published these cases, and he had a volume number, and people started citing to it, and then that became an adopted standard at some point when somebody wanted to adopt the standard, mostly marketing people. So what if there is just an ultimate standard for the multiplicity of sources that are not the right publishing? See, I can't say this, but that was said well. Right here.
yeah.
So that's one way to do this. You
Yeah.
Need a neutral party. As the website, but we also.
So there,
There's this big database, right? Patient data.
yeah.
Wait,
Yeah. So standards are a tricky one. So in my days with John, you had a cartoon that was like another standard, like let's make a standard. And then it was like another standard to compete with another like a standard, right? We have the standard and there's another standard and standard. Yeah, there is a, in terms of like court data, the National Center for State Courts has their open data. They're working on standards for tagging content that hopefully will be a standard. And then the Sally people, Sally has another standard that's working with NCSC too, to have an open data standard.
the open data standards are not necessarily the same.
Right.
And they're not they're doing different things and they're not incompatible with diversification.
Yeah, and I think there's room in this. I'm not saying that open has to be always free, that there is room for a marketplace on this. I mean, Free Law Project, we license our data too to commercial uses of it. But then we also provide it for free to other options.
Last thing.
Sure.
When I said market, I didn't necessarily mean that.
Hmm.
I just meant making universal citation ubiquitous. by having
Available.
a neutral third party to generate them that everybody can use.
Yeah.
And then. And forced adoption of ubiquitous.
Hmm.
I just made them.
Yeah, Tim.
So, you know, we used to send our stuff over to John and he would give us back citations, some machine that you raise through it. To me, I think that with, you know, court listener, and what you guys have, and separately, we grab some stuff too, things like that. There's only a few places that do it for free. They're online, you know, big fine law stuff is sort of paid in bed and stuff. And most people will cite to the free stuff if it's available for free.
Yeah.
So I think the strength that you have is higher than you think. And, you know, we got a few folks that board, you got the Harvard data, you got the other stuff that's out there, that's just straight up, law bonds and this other stuff. The thing that I see as the issue though is the official opinions still go through West. And so we all have slip opinions. But we never get the final version of it unless you like triple key it or something. I don't know, whatever Ed builds it, fast case or something. And that to me is, otherwise, if it was the final opinion coming from the court, I think it'd be okay. And then we could figure out the stuff. You know, once we figure out where a paragraph should start, or
Yeah.
all the extra line breaks, it was. But that to me is the bigger issue. Like you can't even get the official opinions in the Ninth Circuit. It doesn't exist. In Westwood, and I don't know.
Yeah, that's why it has to come from the court, right? The court has to say, this is our opinion, these are the paragraphs, and it's not that hard.
And West does a little bit of editorial stuff every once in a while, but it's normally adding their parallel citations.
So that then just like, you know, do these official citations then point to the authenticated versions of these documents? Because again, you know, what can, you know, somebody who doesn't have the resources to access Lexis or Westlaw, be able to rely on with their official citations?
I mean, the authenticated stuff, I think I don't think that's really there, because I think West and Lexus even have different stuff, and nobody has the same of anything. So it's whether it's really, to me, it's if the court says West is the final thing, because they did that final editorial checks on it. Then we need to get then the court should have to re-put out that West thing, so everybody can grab it. And then, but I guarantee you, if you do like a hash or something, West and Lexus will be different. They check with each other all the time. They don't even have the same sets, right? I mean, Lexus put up all the official opinions. There was, but you know, Andy Process was doing that to try to get more opinions sent back to the deck. So there's all this random stuff going on, but if we get the final official opinions, then it could go to court listener and we do the same thing. We could agree on citation stuff. We'll do whatever Mike tells us. We're pretty easy. We're pretty good followers. Follow Tom Cruise, follow Mike. But we gotta get the official opinions.
Right.
And that's still what drives me, that I see as the biggest issue, because I don't know what to do. Like, I mean, we just grab slip opinions, throw them up, sort of wait for some magic.
Well, it's gonna be a problem more and more now with authenticating with the ones, right? Because right now you can't be sure whether or not something is actually a citation, if it's any of that, or if it's generated by AI, and at least, oh my God, I have to say something nice about them. Lexis and Westlaw are not going to have fake opinions up there, because word is going to get out if they have fake opinions up there, and people aren't going to be using them anymore. So like there is at least a consequence. I mean, it's a pretty hefty stick to make sure that
Eugene Volokh will put it on his blog. But Eugene Volokh will
Yes.
put it on his blog.
So like, I mean, it's one of those things where that's where you kind of, your concern is now with that. And even, I mean, quite frankly, PACER, like the fact that other people, which my disappointment, the fact that the hackers didn't make it free for everybody else, but like, okay, fine, priorities. But like, you know, kind of keeping that in mind with it. And it's interesting because the other thing that kept running through my mind with all of this is that it's like, maybe you have to play the long game and you have to see the thoughts like with law students, and then that would come with the librarians who are teaching legal research and explaining like, hey, you know how you get frustrated when you wanna go onto PACER and like you can't because you have to pay? Like, that's not the librarian's gatekeeping. That's the federal judiciary making sure they have a slush fund. And like, that's gonna go over well. So, you know, but people don't know about, not unless you're in like deep in this. So part of the thing is trying to, that or the fact too, that there's a number of law schools that are making money off of the blue book and like kind of having that sort of a thing, like. I think it's a part of the way the story is being told. Is not helping kind of galvanize people to overthrow.
Yeah. It could be guerrilla warfare, right? Like that's your lever, right? So plant those seeds and see where they grow. In the legal aid space, there's a lot of people don't know that there is an access to justice crisis. They think there aren't enough lawyers, or like, yeah, okay, lawyers are expensive, but like, of course, you know, if I was gonna lose my kids, like, of course I would be able to come up with that money. Like, no, you could just lose your kids. Like, you can lose your house. You can, you know, there are life-changing consequences, and people don't know the volume that others in the community are experiencing it because maybe they don't live in that space. And so just talking about it can really be eye-opening. But we do get pushback from lawyers sometimes about talking about this or talking about access to justice, that it's that's inappropriate. Legal tech shouldn't be used for that kind of reasons. And so you just seed where you can and talk about it and see where those the idea is planted in a law student, or a judge at a bar meeting hears it and is like, oh my God, we need to make this change. You know, like you never know where those conversations can lead.
I mean, a part of it is too, drawing that distinction and saying, cause like, do you want everybody going forth and practicing law? No, there's a reason why it is a profession and you have to go for specialized training with it. Should people be able to access law as just a citizen? Yes, like there is that one. And should the smaller firms be able to compete with the larger firms by having access to the same information? Yes, like it's just one of those things that unfortunately people are, cause no, I think there should be more instruction, more available for people to help understand the context of it, but yeah, I think it's a lot in how we're framing it is a bit of a problem.
Yeah, I think the emergency room idea that you're walking in and they triage you based on, you know, do you have a paper cut or is your leg falling off? Like, the leg falling off, you gotta get escalated, you get the full service and you get that legal aid lawyer or whatever. You know, maybe a nurse can stitch up your hand if it's not that deep, or you like there's different levels of emergency in our legal system as well. Not everything is the surgeon because your leg's falling off. Tim?
Say, no, separately, I think most lawyers have access to fast cases pretty cheap through the bar association. I think the lawyers are okay. I think it's the non-lawyers that are really sort of screwed. It could be anybody.
Yeah.
That needs it. But getting back to the, you know, whether the case is really the case. Like, I'm not worried about court listener having big cases, that's like that. I think they could be trusted, and Eugene could call them out as much as anybody else. Never has, so good so far. But there are blogs and stuff that, you know, take cases and things like that. That's obviously there's some ChatGPT that prices. But even even the Supreme Court, they put up a case as a PDF file, then they change that PDF file without telling you that they had updated, right? And so you don't even know, or a lot of times you'll get like a case will come through like one of the federal circuits or something, and then they redact it.
Yeah.
And they take a whole big chunk out of it, and then they contact you to remove it, and if it's national security, you do it, if it's not. But those types of things happen, and nobody knows about it, right? It's really, you know, it's sort of trying to get the half stuff, trying to tag things. And knowing what's in West and Lexus versus court listener, I think that's something we need to think through, but it should be owned by the courts. And we publish what the court does. If the court makes mistakes and puts out something they shouldn't have, then we have a discussion whether we take it down or not.
Yeah.
And if it's out, it's out. I mean,
Yeah.
to a certain extent.
Every Friday I handle all of our case removal requests. That's my like special little job to decide whether to,
It's a question out of ignorance, probably sheer ignorance, but in Florida, our Supreme Court and now 6 appellate courts publish their PDFs of appeals. We have like, Florida is a very much open records state. And how many states have that kind of system where it's like automatic for their appellate courts to say, here are our weekly opinions?
I don't know, our case
That's
law
the
team
exception.
handles, our case law team handles how we get our content into it.
That are those citables.
Right,
Yeah.
so I was thinking like,
No.
Not all of them.
yeah,
We have unpublished appellate court
Yeah.
opinions.
Yeah, it's not published stuff and non-cited.
but is that kind of like a good place to start with this open citation format and say, okay, I know you're already publishing these
Right.
PDFs.
Do this one other thing.
Yeah,
Like,
can
yeah.
you just add this to there? And then like, if you publish a new version, say V1,
Mhm.
you know, V1.1.
Yeah.
Or whatever.
That's the,
Yeah,
Not.
final.
like, just moving it forward a little past what they know, like, it's not a jump into space. We're not gonna ride on the rocket ship. It's like taking one more step. You're already doing this one thing. Just do with one little more. One
Would you
little.
like to stop subscribing to Luba?
There
You can save this money by adopting this.
you
But
go.
I don't think they're gonna tell you when they make mistakes, is the issue.
Yeah.
Right, because they don't want to be embarrassed.
I mean, people are people, right?
And
It's
they,
still.
they just try to put it out there and they sort of go, hopefully nobody noticed again. So
Yeah.
it's a little bit,
Maybe it's a cultural shift, like an understanding that it's out there because of the internet. And so Ron Stout used to say you'll have innovation in law school, one funeral at a time. So maybe that is the way you seed it with law students, and then those law students eventually become, judges.
well, that's how the Georgia case got ruled. It was the younger folks said there's no copyright in the Georgia code. The four older ones, this wasn't, it wasn't based on, political
Yeah.
background.
So the challenge is how many sleeper agents can you generate? Your
There's a lot of like underpinnings of like bring down the system today.
I'm no longer me, so now I'm.
So I think we all die, just gotta wait.
It's way long enough. Yeah.
Question that kind of hints on that bring down the system thing.
Okay.
And I work at LAI, so we operate in this general space too. And sometimes late at night, one might be tempted to worry about, are the things that we're doing as a Band-Aid, and I don't use that word pejoratively, as a Band-Aid or a tourniquet.
Mhm.
To make a horrible situation livable, do those actually become an excuse for the government to not fix the problem?
Yeah, I
I'm
mean,
wondering if that's something that keeps you up.
the same argument with
Like
court
recap
forms.
can be a reason why somebody could say, well, there's not a huge PACER access problem because people can just go to recap.
Yeah.
And
Or they
that's
say there's
not an answer, but that's an answer you're gonna hear.
Or they say there's every quarter, if you spend less than $35 or something on PACER, well, it's free. Well, okay, but to get a PACER account, you had to have a credit card or you wait in the mail for 2 weeks. Like, it's just ridiculous, the procedural burdens that are put in place. But the same thing with automating court forms. Like, if you automate a bad court form, have you made the process any better? No, you just put it on the internet. It's still a bad form and the process is still hard for
Well,
people,
you let the court off the hook.
right?
It's really their problem.
Yeah. And this is the court, that's where the courts need to take ownership. They need to stop saying, this is the commercial off the shelf, this is the only products we get. Like, no, you are the consumer. Start having some power in your purchasing. Your lawyers start drafting better contracts that, like, Tyler doesn't get to say it's $300,000 if you want to do a small change to your case management system or something like that. Like, ownership, empowerment, and stop listening when they say open source isn't secure or open source is untested. None of this technology is sort of untested.
Well, Tim mentioned the Georgia v. PRO case. Honestly, that outcome was a little disappointing to me. I said that on the podcast and I heard about it from Carl Malamud afterwards. But they had this beautiful 11th Circuit opinion that said what you said earlier, which is the public owns the law. And the public has a right to know the law, and that's why there can't be copyright. And instead of rubber stamping that, the Supreme Court completely threw out that logic and said, no, under the statute, a court can't be an author. And so they backed away from this opportunity to make the strong statement about who owns the law.
Mhm.
So to me, it was kind of a glass half empty. kind
They're
of thing.
wishy-washy, yeah.
But again, it's this notion of you get these moments to sort of hold, and this lawsuit about PACER fees was another. There are these moments that come up where there's really a chance to hold the system accountable. And we haven't quite had the complete victories in those moments that would have really potentially moved the needle in a way that LAI can't, Freelot Project can't, Protesti can't, because there are these institutional obstacles that only the institutions at the end of the day.
Yeah.
can really truly live. All we can do is build workarounds.
I mean, I
Once
agree
you
with-
Start peeling the onion, like, everything falls apart. If you start looking at the different, like, I mean, there needs to be like, oh my god, yeah, blow up the whole system, like, it needs to be completely. Because once you start doing that with it, you start looking at the other things that need to change, and I mean, like, quite frankly, law doesn't like to change.
Sure. That's a whole separate hour.
I know, I'm sorry.
Yeah, she did
Yeah.
write an article called like Burn It Down. So, yeah. If this is.
I'm subtle.
Why she is.
Other question? Sides burn it down? Yeah.
This is a new, it's sort of in the form of idea, I guess.
The thought bubble.
Yeah, so you've had some success, some decent success with recap. What recap essentially does is it drops in between the problem and the user, right? You know, they're on a website that doesn't do the job, but the browser extension says, hey, you know, if you do it this way, then things are better for others and for yourself and others. So you want to sort of, you want to somehow, you know, worm your way between the user and the problem.
Yeah.
Why not another browser extension between the user and Lexis or user and Westlaw, or on any website where a case citation in the wrong format shows up that says, hey, you want to see those case citations in a neutral format with a link to someplace where you can get that? In other words, you can't replace Lexis and Westlaw, but and you probably, because a lot of people, because they pay for a subscription, you know, it's not all you can eat or something like that. Maybe you can nibble away at their usage a little bit with a better what experience, I guess.
There's those keywords sort of in legal aid, the plugin that you could use for legal aid websites or self-help websites if they want to define specific words. Like every time plaintiff is used in your website, if you have this browser plugin, you can see the definition for it. What was?
I know, I can't remember the name.
It's the
of it
right,
now.
I think it's the right clearly folks, but they made
Yeah,
a
it is.
browser plugin
Yeah.
that did like a similar idea. So
So, yeah, similar idea, so.
Yeah.
Hey, I see a
What-
site.
You just need those citations, like they lock those up too, right? They lock up the connections between the citation. Like we don't have, at Free Law Project, like, we don't have recent citations, like for reporters.
yeah, and that's blocking the innovation
No,
that we're
you
trying to
can-
do.
You can regex, you can, okay, this is a big if, and get into the idea. If you can look at any particular text and find out if there's a Westlaw citation on it, then you can offer a court listener citation, a free citation.
Sounds like a fast way to get us.
I don't see how. I mean,
I, well,
breaching any.
I know, but still,
So we
not saying it'd
actually,
be right.
And the user would have to install the plugin themselves,
Yeah.
so, you know.
we actually at LII, we actually have a thing that nobody knows about because we have to figure out how to market it. Called
Right now.
READO, which stands for Read It Online, where if you plug a citation in, it will give you the hyperlink to everywhere that citation can, maybe not everywhere, but all of the big places. If Justia has it, here's where it is. If you have a Westlaw account, this is the link that will take you right through your, put in your credentials and will go and you know, court listener and so that's almost kind of what you're talking. My idea was, this was Peter Martin's idea, because there are some jurisdictions, probably not represented in this room, where in federal courts, the local rule of court in the Northern District of Texas or wherever is you have to hyperlink your citations in the case. You see a couple people nodding. So the idea was, well, okay, you can hyperlink, we're gonna give you a hyperlink that's vendor neutral. So you use this hyperlink, and now if the court is a Westlaw court or a Lexis court, you don't even need to have it paid because it's also Justice got it. And so anybody who's reading that opinion, who clicks on that link, sees the Justice version, sees the free version.
Right now, we're putting up cases that link to Westlaw that you gave
Yeah.
attention. I mean, so like, what was that one decision that came down about the guy who set down Bell Cell?
Yeah.
You wrote it, it's all Westlaw ones. Yeah, the long end. So what you can do.
Yeah, from the Supreme Court, yeah.
Yeah. So we're doing cool things. People are doing cool stuff. You just have to market it, right? Like that's the whole problem, like.
How do you keep Rio up to date?
If we're, what's that?
How do you keep it up to date?
That's a question for Sarah. That's Sarah. But yeah, actually, Peter Martin actually hired his nephew, I think, was the original developer on it, and then when Prototype gifted it to us, and it's been our issue ever since. But yeah, there are options.
All right, so my last one on here is just contact if you're interested. Always happy to chat about it. Thank you for coming. This was a half an hour session, so thank you all for making it a 55-minute session instead. I appreciate that. We have 5 minutes.